Good morning, good morning, good morning. Welcome to our webinar that we've put together for you, our Absa clients and also non-Absa clients who are really interested and excited to learn about what we have for you today, which is building the Hedge, essential estate planning tools to protect family assets. I personally am really excited to listen to what our wonderful panel has to take us through today. One of the interesting facts that I was completely shocked about is that from the Kenyan population, there are only 10% of us who have actually written their wills. And considering how complicated life can get at that point, that is an alarming statistic. And this is why we're here today, is to equip you with the tools that you need to be able to put together something that will protect what you've taken so hard and so long to build. On behalf of Absa, the reason why we brought this to you is because we find it extremely important to ensure that we equip you with the tools that fit your specific life stages. What we have within the consumer business is a curated experience that addresses the needs of all of our clients based on the life stage that they're in. We're cognizant of the fact that you experience life differently at the different stages that you're in, all the way through to when you get your first job, and to the point that you retire in your life, and are starting to plan for your future and your legacy at that point. Based on that, we have propositions that connect with you at those stages, starting all the way from digital banking solutions through to personal banking solutions, and then into the journey of wealth. Within the affluent business, we have 3 sub-segments, starting from Prestige. Prestige is our entry segment. And for us, for me specifically, it's the most exciting segment because that's where the firsts happen for our clients. This is where you start your savings, your first savings or your first investment. You actually are looking at buying a car or investing in your first home. It's a really exciting period. You've just gotten children, if you have, and looking to grow into the journey of accumulating some wealth. The next stage is Premier, where you've already started accumulating a bit of your savings and investments, and are now looking to basically maximize the returns that you're getting on what it is that you've grown and grow it further. And finally, landing into the segment of wealth, where what your primary interest is to ensure that you leave a legacy, and legacy is left through what it is that you've taken a lot of time to build. The conversation today, however, is not only for the wealthy. I think that's also an interesting stat, is that a lot of people think that estate planning is applicable to the wealthy. That's not the case. Estate planning starts from the moment that you have the first asset, first shilling that you've put together. And therefore, this really applies to you at whatever stage that you're in, and we want to ensure that we bring this to you, we empower you to have this conversation and really protect what you've worked hard to build. You will listen to some very interesting case studies and stories as you go through this, which will really bring this home for you, and I really hope that you take a lot from this as you learn. And to unpack this very, very important topic, we have with us Boya Wangongu and Wayaki advocates, the lovely panel that you can see to my right. And I will take this opportunity to introduce the beautiful lady sitting right at the far right, Iveen McKenna. Iveen is a senior associate at Mboya Wangongu and Wayaki Advocates. She has over 6 years experience in estate planning, a certified arbitrator with a solid foundation in dispute resolution. She's a company secretary with a background in corporate commercial law, very passionate about helping clients, and I can attest to this as well, in navigating the complexities of familiar relationships with clarity and care, which is exactly what you need through this journey. So welcome, Iveen. I will then move over to the gentleman in the middle, Peter Wayaki. Peter is a partner at Mboya Wangongu and Wayaki Advocates. He oversees finance and strategy and development at the firm and heads the commercial dispute resolution practice group. And remember, this important subject is not only just for the individual, it can also apply to corporates, and is a very important topic at that level as well. He's an advocate of the High Court of Kenya, a member of the Law Society of Kenya, the Chartered Institute of Arbitrators of the United Kingdom, and the Institute of Certified Secretaries. He is also a certified corporate governance auditor. His passion has led him to also author a book, an inspirational book, which I have learned for the first time today. I didn't know that, Peter. And it is titled A Hopeful Future for Kenya. Finally, I'd like to introduce the beautiful lady to my right, Gladys Mboya, who is also a managing partner at Mboya Wangongo and Wayaki Advocates. She heads the real estate banking and finance and the estate planning and administration practice groups at the firm. An advocate of the High Court of Kenya, Commissioner of Oaths, a notary public, a certified public secretary, a member of the Law Society of Kenya, the Chartered Institute of Arbitrators, and the Institute of Certified Public Secretaries of Kenya. Oh, that was a mouthful for all three panelists. You can just see that we've brought you extremely accredited professionals to take you through this important topic. Gladys is very passionate about helping clients preserve their wealth and businesses for generations to come. To take you through this exciting subject, I'm going to hand over to Iveen, who will talk the panel through and guide us through this conversation. Iveen, over to you.
Thank you, Sima. It is a pleasure to be here, and thank you for having us. Good morning to you all. Thank you for joining. I hope you are excited about today's session and you're looking forward to learning something. And you know what? We also want to hear from you. We want to hear, what do you know? What can you teach us? What are some of the issues that maybe are pain points from you? So this is me just encouraging you to please engage with us in the chat box section. It is at the bottom of your screen. And any questions that you may have, please direct it to the Q&A session. Q&A bit of the section, and we will ensure to answer as many questions as we're able to. So we are looking today at building the hedge, essential estate planning tools to protect family assets. Why are we discussing this? As Sima has stated, a lot of people focus on building a lot of wealth, and then they forget to plan how it will be used when they're not here. And maybe even just to debunk a bit of myth, a lot of people think that they only need to plan for when they're not here. But a lot of estate planning tools are required even during your lifetime. Something that you can start planning now, in case maybe you get incapacitated, you're still alive, but you're not able to care for your estate and to care for your beneficiaries as you would if you're fully abled. So this is why it is very important to have this topic and this session to discuss what can I do to plan my estate now? And the emphasis today will be that you need to start now. So please let it ring in your mind that everything that we are discussing, we are really advocating that you begin now. We are going to discuss a lot of different tools in the estate planning. But first, I want to begin with just giving you a training outline on what to expect today. And we would also like to hear your comments about what you also expect to learn today. But what we have prepared for you is the first bit, just to understand why have an estate plan at all? Why are you forcing this down our throats? A lot of people feel like it is something a conversation they would rather postpone as much as possible. And we're trying to tell you that it doesn't have to be a difficult conversation. It is something that you can start planning slowly. And we will look at what an estate plan is. We will look at why an estate plan matters, why you should have it, and what are the risks of not having an estate plan. I feel like for a lot of people, you already know some of the risks. You've probably experienced it personally in your family. So you know what the issues are, and we are going to urge you today to see why you need to plan your estate. Then we will discuss some of the essential estate planning tools, a lot of them, but we will do a deep dive into wills and trusts so that you can understand how you can use these particular tools to plan your estates. But before we begin, because we really want to engage with you, I would like to hear from you all. Just put it in the chat box. What do you understand about an estate plan? What do you think it means? When you hear estate plan or succession plan, what comes to your mind? Yeah? So put it in the chat box. I'd love to read some of your comments. And then what are some of the fears that you have about planning your estate? Or what are some of the fears that you think your parents have about planning their estate? Or you've seen people, why do you think people postpone this important venture? So I will read some of the comments. Someone has said they would like to know what the benefits are of having a trust as part of an estate planning. So you're going to learn that today. Are there any tax benefits in Kenya? And they hope you tackle this. We will tackle some of this. Someone else has said allocation of your properties when you're long gone. That's what you understand about what an estate plan is, which is good. Fears, someone has said price. It's a common thing. Yes, I mean, the thing is with price is you're going to pay the price either way. You can pay it before, which is more something you can negotiate, or you can pay it after when you're fighting in court. Which price would you rather pay? There's a price to be paid either way. Another fear that people have, being challenged. So you fear that you may have an estate plan, as I understand it maybe, and that it will be challenged. So you're looking to see how you can ensure that your estate plan is not challenged. We will discuss some of that. Estate planning to me means ensuring that what I have worked for goes to the appropriate people. That is true. And someone else has said, estate is everything I own. Estate planning is arranging what happens to my estate when I'm gone. That's good. It is interesting that a lot of you only think of estate planning when you're gone. And we are going to show you that you can also plan your estate during your lifetime and why it is important to plan your estate during your lifetime. So I'll read a few more. Another fear, superstition. Yeah, we are aware that there are people who believe that if they plan their estate, they're not living more than 6 months before they're gone. And can I just say that is not the case? Yeah, and a lot of these superstitions need to be debunked. And when your time comes, it's your time going to come. Whether or not you had done a will or not, it will come. But doing a will or doing a trust does not mean that you will invite death. And that is one of the myths we must debunk. One of the hindrances of taking up estate planning in earlier life is the view that it is service for the rich. Yeah? People who might be open to it will feel shy because they feel like they don't have enough to plan. Again, we're going to debunk this and say that you have something to plan. And you'd rather plan the little you have, and as you grow, you continue planning, because once you have an estate plan, it is easier, even as you grow, to include the new assets that you have in your current estate plan. And now you know the direction you want to take. So we are going to discuss that also a bit more. So because there are many, thank you so much for your engagement. I won't read any more, but we will be sure to ensure that we answer a lot of the questions that you have. And to begin, and just to help you understand what an estate plan is, why you should have an estate plan, what the risks of not having an estate plan is, I will invite Gladys to take us through that session.
So we're going to look at what an estate plan is. And I think a good number of you have actually indicated that you understand what an estate is. An estate is your free property. That is what an estate is. And so an estate plan is a coordinated strategy for managing, protecting, distributing your assets during your lifetime and after death. Of course, once you do a plan, you're doing a plan while you're alive. You're doing a plan now. And the whole idea of doing this plan is to ensure your family is well protected. So a good estate plan ensures that your wishes are respected, your family is protected, and your wealth continues to serve its purpose. Your wishes are respected. So the fact that you have a plan means that you have worked so hard, as Ivan had said, all your life. You've accumulated all this wealth. You've accumulated all these things. You have a family. You want to ensure that, how do I want my asset to be managed? I want to plan for it now so that even when I'm not here, it will continue. You want to leave a legacy. Leaving a legacy means you have to plan. And an estate plan is one of the ways that you're going to plan for your legacy. And so let's moving on. Why does it matter? Why does it matter for us to have a plan? It preserves wealth and ensures smooth transition of wealth to other generations. I think Sima talked about the fact that there are just like 10% of people who have written wills. When it comes to wills, when it comes to transfer of wealth to other generations, the statistics are also quite low. You know, for property or businesses to move on to the second generation, you have only like about 30%. By the time it's moving on to the third generation, it's only about 5%. And the reason it's this low is simply because we did not plan our estate. And so an estate plan matters. It helps to reduce disputes amongst heirs. You want to ensure that you have a plan so that the disputes will be reduced. It doesn't mean that it might end the disputes, but it might reduce them. So for example, you have 2 wives, and you and your first wife had bought a house together. You know, that became your matrimonial home. It's a beautiful house in Runda. Then you go and get a second wife, and the second wife is living in a rental property. And then you pass away without a plan. What happens? Does the first wife lose her house? Does the one who lives in a rental property get nothing? This is where all the disputes begin. And so it is important to have an estate plan. I cannot emphasize it more than that. It provides certainty. Who gets what, when, and how. You decide who will get what, who will get when, and how. You will remove all these things of people saying, I was the last one he spoke to. I spoke to him just before he died, and he said A, B, C, D. I remember when my mother-in-law died, we had some relatives coming and saying, oh, no, she promised me that plot of land at the corner. She told me just before she died. And they weren't even together with her just before she died, but everybody had the last word. So it provides certainty. It protects minors, children. If you have young children, who's going to look after them? How do you want the education to go on? Do you want them to have the same education that you would have given them had you been alive? Make sure you plan for them. What if you have children living with special needs? Who is going to look after those children? Who is going to look after them? How are they going to be managed? Does somebody know what their routine is? Does somebody know who their caretakers will be? The kind of medical care they need? All these are taken care of when you have a proper estate plan. And it allows you also to plan for your own incapacity. I have a very close friend of mine. He's a much, much older man, and he has very young children, a very, very young family. He married late. And his concern was always, I will not live long enough to see my children marry. And what he did, he planned his estate. He planned his estate. He had trusts, he had trustees. And right now, as we speak, he's suffering Alzheimer. Even when I go and see him, he can't even remember who I am. I have to keep on reminding. But guess what? He's being taken care of. He had left a plan. So medical is taken care of. His food is taken care of. His children are being taken care of. They're in college, they're in school, and they're still being protected. Why? He foresaw and he left an estate plan. Had he not, we'd now be having a lot of the issues that we see today. And maybe we can look at some of the risks of not having an estate plan. Is that, number one, the Law of Succession Act will decide who gets what. So the rules of intestacy, what we call the rules of intestacy, will apply. And so the court will decide who will be the administrators for this estate. Maybe I would have wanted my sister or my brother to be the administrators. But my sister and my brother now cannot be the administrators. It'll have to be the immediate family. And maybe you are not even getting along with your immediate family members. Or maybe your son or your daughter are the most disorganized people. And they are not the people you'd have left as executors. But the court will now decide it's one of them. It's one of them. So ensuring that you have a plan ensures that you will choose your executors. The distribution of your assets will be done the way you wanted. You may want one son to get a shamba. You may want a daughter to get a car. It depends. But once you don't have a plan, everything is more or less equal. Even for those other wives who may come into the picture, everything is equal. And then you'll end up having long court processes, costly litigation because people are not getting along. People are not agreeing. They're saying, no, I think this was mine. I was told this was mine. And then disputes among dependents and, of course, fracturing of family relationships. And we've seen it. It's not something new. We see it in the newspaper all the time. We see how property is wasted, mismanaged. And many times when you don't even have a plan, before you get a grant from court, you cannot access money. So, for example, you have to pay, let's say, land rent. You have to pay school fees for children. You cannot access money from the banks. And you guys are banks. You guys will not give us money until we give you a confirmation of a grant from a court. And that can take so long, depending on how long we are fighting in court. And so we look at this case of Koinange, the Koinange estate disputes, which has gone on for more than 40 years. Every time it looks like it's finishing, every time it looks like it's coming to an end, another dispute arises. And recently, another dispute arose. 40 years. It has taken 40 years. That's how long a dispute can take if you do not have a proper estate plan. Who ends up benefiting from these disputes? Okay, us lawyers, many times. And I had read somewhere, I don't even know if it's true or not, but I had read somewhere that the fees for the lawyers up until a few years ago was about 1 billion shillings. Why would you want to waste all that money giving it to lawyers when you could sit down as a family, plan your estate, and ensure that you avoid some of these things? A good estate doesn't mean that somebody will not go to court. They may go to court, but they may not win because you have planned and have planned clearly. And so I want us to just look at a discussion question that I'll hand over to Ivan to take you through. We just want to see if you're getting an understanding of what we're discussing, and then we'll take it from there.
Okay. Thank you, Gladys, for that. So there's a discussion question up there, and I think Gladys has discussed some of the risks of not having an estate plan. But we want to hear from you. What have you seen yourself? What have you experienced in your family, or have you seen in your friend's family, or in any other situation, or even in the newspapers? What are the disputes that arise when there's no estate plan? Or even if there is, what have you seen? What do people fight about? So we'd love to hear from you. And just please put it in the chat box. I will read a few of your answers. But I think one of the common ones, and maybe we can discuss that, is the Jenga Karume one. And a lot of people suddenly became very scared of trust because of that case. Yeah? Because of how some things went wrong. But maybe just to highlight that in that case, actually, the court upheld the trust. A few things were changed. The trustees of the trust were changed, but the trust still continues. Just that to show you that even the courts are trying to ensure that whatever estate plan that you've put in place remains and that it is honored. And even if there's any mismanagement, then you handle the mismanagement and remove the people who are mismanaging, but the estate plan continues. So someone has said the Karima family. Yes, we've seen a lot of them fighting for land, houses, Jenga Karume. I've seen court cases contesting a written will. Yes, and we can look at in what instances do people contest written wills and why. I can tell you for sure, if you write your will when you're in a hospital bed, someone will try and contest it because they're saying you did not know what you're doing, which is why you have to write your will now. When you're healthy, completely healthy, no one can question that you are aware of what you're doing. I know of a case with a plan. A mom is being sued for not distributing assets to the children. We've seen that. And we've seen how entitled children are starting to become. And so because you know your children, do you want to figure out maybe what is the best estate plan for them? Maybe distributing and giving them the house at 18 is not the best way. So what should you do? How do you ensure that they don't get it at 18? They get it maybe at 30 when they are more responsible. And we will discuss some of those estate plans. We've seen greed of some family members. And just to state, the extended family members will only come if you have no estate plan. I've seen enough clients where once they heard there was a will, they left, because they knew that was going to be a battle. So just having an estate plan alone guards you from some of this. Illegitimate children, we will discuss that. Are there illegitimate children, and what is their place in the estate plan? New kids coming out of the woodworks, yeah? Again, we will discuss that in the next bit of the presentation. And just to help you understand what is the place of children in estate planning. Can they be excluded? Can they be included? When should they be included? Do you need to get DNA samples? Yeah? And I think we know of a famous case where something is happening in that line. when culture dictates that the boys inherit, or if a father writes a will, he's calling death. Okay, so that one of boys inheriting, we will discuss it too, but the law has changed that quite a bit. It doesn't mean that people are still not trying to fight it. A lot of people are still trying to fight their sisters on this issue, which again, having an estate plan would protect you from, but the law is now very clear that everyone is equally entitled to that. So thank you for sharing some of the disputes that you've seen. Now, because you are very engaging and I'm very, very happy to just hear from you guys, I want us to look at this case study. And I want you to envision yourself as a judge in court, yeah? So this is a case that has come to you in court, you are a judge, and you need to settle some of the disputes that have arisen from this family. So the case is about Maendeleo's family. He was married to his first wife under customary law and had 2 children with her. And they were married for 20 years. But after the 20 years, they fought, something went wrong, and they decided to go their separate ways. Maendeleo moved on and started living with a girlfriend who came with 2 children from her previous marriage, and together they had 3 children, 3 additional children. Then Maendeleo unfortunately died at 70 without a will. And he was still living with his girlfriend at that point, so they never solemnized their union formally. So now there are disputes that have arisen in that family about the estate plan, and they've come to you as the judge, and they're asking, can the first wife inherit from Maendeleo's estate? The other question that is before you is the girlfriend who he has been living with and who they have 3 children with now, is the girlfriend considered a wife? And should she inherit from her estate, from his estate? And in addition to that, the stepchildren of Maendeleo also want to get something from the estate. Should they be able to inherit from Maendeleo's estate? So I'd like to hear your views on that, and to do that, we will launch a poll. So it should be coming up in a bit as you read. So there's a poll. Please answer the first question. They're all yes and no answers. I just want to hear from you and what you would do as a judge. Can the first wife inherit from his estate? Yes and no, or no? Can the children from the girlfriend's previous marriage inherit from his estate? Yes or no? Is the girlfriend considered a wife? Okay, so the results of the poll. Can the first wife inherit from his estate? 93% of you say yes. So 93%. Then can the children from the girlfriend's previous marriage inherit from estate? This is very interesting. 49% of you say no. 49% of you say yes. 51% say no. So wow, that can really go either way if you are the judge, yeah? And a lot of these judges, by the way, are also human beings with their own family backgrounds. If you find one who was a stepchild, maybe would have voted yes, but we will discuss what the position of the law is on that. So that's interesting, tight answer there. Then the last one, is the girlfriend considered a wife? 47% of you said yes. 53% of you said no. Again, very interesting. So we want to discuss, thank you so much for participating. We will discuss some of these issues and what the law says about them and what you can do when planning your estate to ensure that you consider your circumstances. And we encourage a lot of people to consider their circumstances at home and to come up with the best estate plan to ensure that every issue is handled. So we will move on to the next bit, which is now discussing the essential estate planning tools and what they are, what they comprise of, and I will invite Gladys to take us through this session. Karibu.
Thank you. Thank you, Ivan. So let's delve in. Thank you guys for participating so energetically. What are the essential planning tools that we have available to us? We have a number of them. We have a will. At the very basic level, we have a will. And it's a legal declaration directing asset distribution after death. A will is one of those things that everybody should have, regardless of what other tool you want to use, you must have a will. And we encourage everyone to have a will, even if it's just a 2-page will. Some of you talked about the cost and said, oh, it's very pricey. If you're part of the Absa customers, we have given you very, very good rates. And I think if I were you, I'll take advantage of that. So it's not expensive, but it's one of the basic tools that you will need as part of your estate plan. We've got trusts, and Peter will be talking about trusts, which are structures for asset protection and management across generation. And a trust will ensure that your wealth is actually preserved for generations to come. We have joint ownership of assets. And this is shared property rights with survivorship benefits. So, for example, you'll find a lot of times you'll find a husband and wife will have a property in both their names. So it'll say this property is owned by James and Mary jointly. Once it says that, this particular type of asset means that you don't even have to go to court for probate. Once one of them dies, the survivor takes it. It's the rule of survivorship. So if the husband dies, the property automatically goes to the wife and vice versa. So a joint ownership of asset where it's jointly owned is one of the estate planning tools. You have nominations, which Ivan had talked about before. It's a direct beneficiary designation for insurance, pensions, and SACCOs. Most of you who are in SACCOs or have insurance or have pensions will have a form where you're asked who will benefit. In the event that you're not here, who will benefit? And you will put down my children or my wife or my husband. That's what you put down. So that doesn't have to go through a will or through court. The moment you die, the person that you have designated as the person who is going to inherit is the person that will take it. A bit of a proviso here. A lot of people, when they started working, put down, for example, you're young, you're unmarried, you put down that the person who will benefit will be my mother. Then later on in life, you got married, you had your own children, but you never changed that designation. It's important to always look at what you put down in your insurance and your pensions and in the SACCOs to ensure that the people who you want to benefit are the right people. We had an incident a few years ago where a man died and he had left the nomination. The beneficiary was to be his mother. But he had married, he had a son. His mother did not like the wife at all. Guess what? All the money went to the mother. She didn't. Not only did she not share it with her daughter-in-law and the son, but she left the country. And they were left literally poverty-stricken. Make sure that you choose the right people. Make sure you continuously ensure that designation is taken care of. Another estate planning tool is gift intervivals. I can decide, let me give my gifts to my children now while I'm alive. I'm transferring this gift, I'm giving you this property, I'm giving this car, I'm giving you this land now when I'm married. And so later on when we write a will, we will say, the reason I have not left something for you is because I gave it to you while I was alive. So you can give gifts while you're, and the good thing of giving gifts while you're alive is nobody will fight it. There'll be somebody else will not come and say, no, I can also benefit from that because it was already given away. You've got powers of attorney, which authorizes others to act on your behalf in the event that you're incapacitated, in the event that you're not in the country, anything. But a power of attorney ceases being effective upon your death. So a power of attorney is only effective up until you die. And then you've got health directives. And usually people will do this either through a power of attorney where you will inform whoever you want to inform that in the event that I am very ill, I want you to be the one to take care of me. I want you to ensure that my medical treatment is taken care of. So you can nominate somebody. In other countries, especially in the US and the UK, they even have what we call living wills, where you say, in the event that I'm end of life treatment. I don't want to be resuscitated. I don't want this. I want, when I die, that my organs will be donated for research, etc., etc. And you can nominate somebody to do that. We have not done that so much in this country, but it's starting to take traction. Okay. So let's go to the very basic that I said, wills. What is a will? I had described it. It's a legal declaration by a person of their wishes or intention regarding the disposition of their property after death. So it's about how what's going to happen to my property after I die. A will can be written or it can be oral. And it takes effect upon death, which means that you can modify it anytime. I have some really good clients who every year they come and they change their will because something different has happened. They've either acquired something new or they have disposed something that they had, and they're very diligent about it. So the good thing with a will, you can change it anytime. And it must be in accordance with the Law of Succession Act, so for it to be valid. We've put here a discussion point about the validity of oral wills. An oral will means simply you sitting down and telling people that I want this property to go to James and John. You must have witnesses. The same way you have witnesses in our written will, you must have witnesses, 2 witnesses for your oral will. But the oral will is only valid for 3 months. So either you die within 3 months, or after 3 months, you do another oral will. An oral will is only effective for 3 months. There was an issue where we've seen people using audiovisual. You've got a video and you're videoing your wishes. And the courts have said that is an oral will. So just like an oral will, it's only valid for 3 months. Why do we make a will? We want to maintain control of a property after death. We want to avoid disputes over property after death. I discussed that a bit earlier. We want to avoid the rules of intestacy, where the court is the one that determines for you how your property will be divided. You want to appoint testamentary guardians for your young dependents. You might have young children, and maybe you're a single parent, or maybe you're not, but you want to ensure that in the event that we are not here, who are going to be the guardians for our children? You want to be able to write down who your and you have to ask them, of course, would you be a guardian to my children? You don't want to surprise people. You want to create trusts over assets where needed. Peter will be talking about trusts, but I want to mention that even in a will, you can have a trust, and we call that testamentary trust. And when Peter talks about that, he'll describe that a little bit more. You want to be able to appoint your executors. Who are the people who are going to manage my assets? Who are the ones who are going to be the ones to distribute my assets? You have to appoint them, and they're called executors. When you have a will, they're called executors. When you don't have a will, they're called administrators, but they're the same things. They're the people who are going to manage and distribute your property. You want to prevent waste, resources, and mismanagement of assets. Do you know that every time we sit down to do wills with our clients, many of them had even forgotten what they had. They forgot that, oh yes, I had bought a plot in Kitengela. If they died and nobody knew about it, that's it. Who is going to come and claim it? Nobody knew. It was just your own little secret. That's the reason why you put these things in a will. And then it allows you to have freedom. Freedom to give whoever you want what you want. I want to give my children, but I have a really close friend. I have a worker who has worked with me for so long, and I want to be able to leave something for them. So this freedom is given to you when you have a will. If you don't have a will, you cannot give to a worker, you cannot give to a friend. If you don't have a will, it's only the immediate family that will benefit. Who can make a will? Anybody. As long as you have capacity, as long as you're over 18, and as long as you are of sound mind. You must demonstrate free will and intention to make a will. Somebody mentioned the Kirima case earlier. And one of the reasons why the will was thrown out is because they said by the time he made the will, he was too sick. He probably did not have the capacity to do so. And I think he had 2 wills. I think the first one they had said he was under duress. So if you don't have, if you can't demonstrate free will and intention to make the will, then that will be invalidated. Yeah. And the maker of the will has the freedom to dispose of their property as they choose. But they must all make reasonable provision for all their dependents. So testamentary freedom is curtailed there a little bit because you can distribute it how you want, but you have to leave reasonable provision for your dependents. And I think it takes us to the next slide, which talks about the key partners in a will. What are all these names? Testator. Testator is the maker of the will. So you who is making the will is the testator. The executor, as I said, the other name for an executor, if you don't have a will, is an administrator. So it's a person named by the testator to carry out the directions of the will. And an administrator or an executor cannot do anything outside what the will says. They can't determine things for themselves. The will has said, this house is going to James. So me, Gladys, as the executor, my job is to ensure that that house goes to James. It's as simple as that. It's administration. And then the beneficiary is the person who will benefit, who is being given an asset in the will. Okay? The other parties in a will, we've got trustees, because like I said, you can have a trust inside a will. And Peter will talk about that. And so a trustee is the person who is named by the testator to manage the estate's assets for the benefit of the beneficiaries. And usually you'll have a trustee, especially if you have young children under the age of 18, and you want to leave something to them. The trustee is the person who will actually hold that property until the person comes of age. And then you have a guardian. We discussed about guardians, and that's the person who will take care of your children in the event that you're not there. What are the makings of a valid will? It must be signed by a testator, or if he can't sign, you can put a thumbprint, or if you can't even put a thumbprint, it must be under the direction, but in his presence. So he may not even have hands, but he can direct that somebody signs on his behalf. Signing of the will by a testator must be witnessed by at least 2 competent witnesses who saw him sign it. So a lot of people don't want to do their wills because they feel like, why should somebody look at my will when they're signing it? When we're talking about signing, the person doesn't have to look at your will. You've done your will. All they are doing, all the witnesses are doing, are witnessing that you signed it. That's all they're doing. They're witnessing your signature. So they don't have to see the contents of your will. And the witnesses must never be the beneficiaries. So if you're leaving something for your son, he must never be one of the witnesses. Otherwise, you will invalidate the will. Okay? We talked about leaving reasonable provisions for your dependents. Who are dependents? Who are they? These are the people who are entitled to inherit from the deceased estate. And they're divided into 2 categories. There's the automatic dependents, those who don't need to prove dependency, and those who need to prove dependency. Who are the people who don't need to prove dependency? Automatic children. As long as I'm your child, I don't need to prove that I am a dependent. I don't need to prove that you are giving me money or I am your child. As long as you have sired a biological child, we don't have to prove dependency. That child must be provided for, whether legitimate or illegitimate, as they say. Although these days, I think even that word, I'm not sure if it's politically correct. But as long as you have a biological child that you have sired within your marriage, out of wedlock, that child must be provided for. And they don't have to be 3 years old. They can be 70 years old. You have to provide for your children. Those children who are conceived but not yet born, children who are adopted, because of course children who are adopted are now considered your children, and then children over whom the deceased assumed permanent parental responsibility. I may have come into a marriage with a child, and my husband assumed permanent parental responsibility over that child, and maybe even gave the child his name, his last name. So there's an assumption that you wanted permanent responsibility for that child. That child also does not need to prove dependency and must be provided for. If the child has another father, for example, and that father, and it's just that we are divorced, and the father, they have visitation rights with the child, it means that I've not assumed permanent responsibility for that child. I don't have to live for that child. So other dependents are spouses, including people who are considered wives for marriage purposes, who are not considered wives for marriage purposes. So a spouse who you must live for something is your husband or your wife, or a wife who is not considered a wife for marriage purposes. So under the Marriage Act, there are 4 ways in which a woman can become a wife. Under Christian marriage, civil marriage, Hindu marriage, Islamic marriage, and customary marriage. If you have a wife like that other girlfriend who does not fall under any of those categories, they can be considered a wife after your death under the Succession Act. It says if a woman, if you are married under customary law to another woman, even though you had another wife, or even though you married another wife afterwards and entered into a monogamous relationship with another woman, that person, that one, is considered a wife and also doesn't have to prove dependency. You must provide for them. You must provide for a former wife, but for a former wife, a wife that you have divorced, if you can prove that you gave them alimony and you had a settlement, then you don't have to provide for them. But if you haven't done that, even a former wife would have to be provided for. Cohabitee. You provide for a cohabitee, somebody that you've lived with for a long time, where people will say, surely these are husband and wife. You have to prove that they have stayed together for a long time. People consider them husband and wife. Those are wives under the Succession Act. Can we continue? There are those who need to prove that they were dependent on you. And now these are your parents, your step-parents, grandparents, grandchildren, stepchildren, children who the deceased has taken in as his own, like the one I had said, but maybe did not assume permanent responsibility, brothers, sisters, half-brothers, half-sisters, step-brothers, the whole shebang. All these have to prove that you are maintaining them immediately before your death. So they have to come and show, look, he had been paying school fees for me. I'm in Form 4. He had been paying since I was in Form 1. You have to prove dependency. So there's those you don't have to prove, like children and spouses, and those that you have to prove. And then there's all these properties that can be put inside a will, which is land, movable assets, money in bank accounts, shares in companies, intellectual property, digital assets like cryptocurrency now. A lot of cryptos are getting lost because people die and no one has their password. All these things can be put inside a will. Two of the special features that we have in a will are what we call the residual clause. The importance of a residual clause is that it covers every property, even the property that you yourself have forgotten. And it covers any property that you subsequently buy and did not put in the will. So it's a cover-all clause. It's an important clause in a will, and even if you didn't mention it inside your will, the fact that you have this clause in the will will ensure that it's properly taken care of. And then testamentary trust, I think I talked about that, and I said Peter will have a discussion about that. Okay? So thank you very much. I think we'll move on to the next topic. And I'll invite my partner, Peter, to take us through that.
Thank you very much. I'm happy to represent the boy child. I know the boy child is greatly besmirched when it comes to wills and inheritance, partly because they've been historically favored, especially under African customs. Come last in the presentation just to emphasize that point, and I'm not even going to talk about wills, I'm going to talk about trusts. So, very quickly, because of time, what is a trust? A trust is a legal arrangement where set law transfers assets to trustees to manage for the benefit of beneficiaries. Keywords here are, there's a set law. This is the current owner of the property. He transfers assets. So there must be assets which are the subject of a trust. Then they are transferred to somebody called a trustee. And that trustee can be the same person who is the former owner, can be other people, can be more than one person. And what's the purpose of that arrangement? So that the trustees can manage their assets for the benefit of the beneficiaries. And again, the beneficiaries may actually include the former owner. And I'm using the word former owner deliberately, because once you create a trust, transfer the assets, then you are no longer the owner. Who are the new owners? The trustees. For what? For the benefit of the beneficiaries. A trust can be a living trust or a testamentary trust. Living trust means you've created the trust, you've set it up, and you've operationalized it during your lifetime, as opposed to a testamentary trust, which you create or establish through your will. This is to say, in a will, as Gladys said, you can give away assets freely, absolutely, transfer them to people that you want to give, and who will get it after you die. Or you can actually transfer assets, all of them or some of them, into a trust. That means you've created a trust using your will. That's a testamentary trust. What is the law that governs trusts in Kenya? There's a Trustees Act. And more recently, what has come to the fore a lot is a Trustees Perpetual Succession Act. And the reason for this is because a few years ago, it was amended to include what is now called a family trust, which I'm going to come to shortly. But just to point out that currently there is a draft law before Parliament called the Trust Administration Bill of 2025. When finally our honorable members of Parliament come round to discussing it and passing it, then it is intended to change the whole trust environment, trusts environment in our country, and change the law, basically redo the law on trusts. But why would you want to have a trust? We've said you could have a will, but a will is not always sufficient. It's not always the best tool, depending on your circumstances. One of the things that you achieve using a trust is that you protect your assets mainly from wastage or even from loss. By putting your assets in a trust, you are saying, this is how I want, these are, first of all, the assets, because to put assets in a trust, you must identify the assets. It's actually one of the things, principles in law called the certainty of the subject matter. What is it that you're saying you're transferring to a trust? It must be clear what that is. So inevitably, unlike a will where you can do a general statement, I transfer all my assets to my wife and children in these proportions, in a trust, you have to identify what are the assets you're actually transferring to a trust. Is it this property? Is it this rental? Is this vehicle? You have to identify them. That way, you actually protect your assets from waste and loss in the event that you are not there. You inevitably identify them. It also helps in promotion of good corporate governance. There are people who, because of where they work and the conditions under which they work, they may not be able to run their businesses properly. So they can put them under trustees, then the trustees can carry on the governance of the entity that is doing the business. But in addition, coming to the issue of diversification of assets and avoiding conflicts of interest, who the terms under which they work, they may not invest in certain investment. For example, if you're a consultant with a certain consultancy firm, the rules of employment may be you cannot invest, say, in a company where you are auditors or with whom you consult. And this means you may need to keep changing your portfolios as the business grows, and it's not even your business sometimes. By putting your assets in a trust and having somebody else run that for you, and you not being aware of where the investment even is being done, you are able to participate in a wide array of assets that you otherwise would not be able to do if you're doing it directly yourself. And a famous case for this one is a former Senator Mitt Romney, when he had to run for president in the US, and he puts all his assets in a trust, so they could invest anywhere, and he wasn't aware where they were investing, and he could not be barred because it was not part of the decision making for his investments. I'm sure there are many who do that in Kenya. We just don't get to know some of those. It ensures privacy. Ultimately, a will becomes a public document. Why? Because after somebody dies, it must be probated in court. When it's probated in court, that's how we get to know what Jenga Karume wrote or did not write, what Kirima wrote or did not write, the Koinanges, what they did or did not do, and so on and so on, because a will ultimately, and probate and applying for letters of administration is a public process that goes through an open judicial system. However, trusts, unless they are litigated, are not public, and they never have to be public. So they ensure privacy. Certain prominent families that have trusts, none of us knows what is in those. None of us knows what the assets are. And that is the sort of situation talking about when you have a trust. It ensures privacy. It provides for dependents appropriately. You need to know that once a will is probated, then assets must move to the beneficiaries. It doesn't matter that that beneficiary is chaotic. It doesn't matter that he's only turned 18 and 1 month. He will get his assets. Now think about it. If you've been working very, very hard, you even married late, trying to work for the future generation, you finally do a will, and at 18 and 1 month, your very chaotic son gets hold of 1 billion shillings. What is he going to do with it? Now, how do you cure that? Put it in a trust for him. Then you can say, let him be given when he's 28, for example, or when he's finished college, or when he's 35, whatever it is that you want to do. And yet you provide. And you also make sure somebody else is managing that asset for him in the meantime. Trust also helps us to avoid lengthy probate proceedings. Everything you said about wills, and wills are good, but they can be highly litigated. And of course, it helps us with tax planning. There are tax benefits which are to be enjoyed when it comes to when you use trusts. For example, you can transfer assets into a family trust without paying stamp duty under certain conditions, without paying capital gains tax under certain conditions, and that helps you to manage your tax. So we will not go into all the details about what you can save, what you cannot save. That is a lot more detailed discussion. But I've mentioned a few times the concept of family trust. The family trust is defined in the Trustee Perpetual Succession Act since a few years ago. And this is a trust, whether living or testamentary, partly charitable or non-charitable, that is registered or incorporated by any person or persons, whether jointly or as an individual, for the purpose of planning or managing their personal estate. And it is established for the purpose of preservation of creation of wealth for generations. When you talk about trust, you hear us talk a lot about generations. The whole thing about estate management is attempting, to the extent that you can, to move assets and property from one generation, the current generation, where the wealth was made, to the next generation, and hopefully to G3, G4 generation, third generation, fourth generation, into the future. So for family trust, is specifically so that assets can run down the generations. And why would you want to do that? Mainly to manage family wealth. You, again, do not want to live a situation, say you own a business, a very prosperous business. You do what? You do cement, for example, very, very prosperously. And you leave shares to your children. Now, one of your children may choose to sell their shares to anybody, and the family members may not be in a position to actually buy those shares. What happens? It means the family business is starting to be, diluted. It's starting to fall into other hands that you may not have wanted them to fall into, and so on and so on. So by having a family trust, you manage property within the family. Let's move on account of time. How do you create trusts, including family trust? You create trust using a trust deed. We said a living trust. You create a trust deed. You just sign a trust deed saying, I am establishing a trust. I am moving these assets to be held by the trustees as trustees, not to be held any longer by me as a person who owns them or own them. And this, when you create one by trust deed, then you can decide that it starts to be operational immediately, and you can start transferring the assets to that trust, rather to the trustees of that trust. But you can also do it by will. If you do it by will, it becomes effective. Because the will becomes effective on the death of the maker of the will, then any trust under the will or created by the will also become effective upon you dying. Now, what is a slight danger with that is that if the will were ever to be challenged, and if the challenge were to be successful, then the trust may also be successfully challenged, or it may cease to be. For example, if the will was found to be invalid, wasn't properly signed, therefore it's invalid, then the trust created under it also becomes invalid, and that may not be good. So you've got to be very careful how you draft it if you choose to do it using a will. A few points of discussion. Can a family trust be revoked? Yes, it can, but there are certain tax implications if you revoke the family trust, just like any other trust. Once you revoke it, then certain things will happen. If you create it as revocable, meaning you can change it, you can undo it, it means that the tax benefits I talked about, you may not enjoy those ones. Must my beneficiaries know the details or contents of the trust? No, they don't have to know. There are different kinds of trust. There are what we call blind trust, bare trusts, and so on and so on, different kinds. In a blind trust specifically, nobody need know, first of all, that there's a trust, or secondly, what they're entitled to. You disclose as much information as you wish. And in a blind trust, for example, somebody just receives maybe a check, maybe some rental. They don't know what else is coming. They don't know when it will come. They don't know whether to expect or not to. And these are devices used for various reasons. You may have this guy who, as a parent, you know, once this guy knows how much is due to him, he'll never work again in his life. He'll be playing golf the rest of his life. So you want to limit the information that he has, and so that he can hopefully keep working. And 1 month when he thinks he's going to receive some money, he doesn't get anything, for example. So nobody need know what is in your trust if you don't want them to know. But there are types of trust that if you create, then you have to allow information to go out to the beneficiaries at least. What happens if I change my mind after creating the trust? If you create it as revocable, then you can revoke it. Of course, there are times that you can create for certain beneficiaries, and some of the beneficiaries die before you, and you can adjust. And the way we draft trust is that benefits can actually move along should one of the beneficiaries not be there. Moving right on, and hoping to finish this very quickly. Who are the people involved? We've talked about asset law. That is a person who creates a trust. He's the one who transfers assets to the trust. And they're trustees. Trustees come from the word trust. They must be people who can be trusted to run and manage the assets of another. Moving on is, of course, the beneficiaries. These are the people who must be clear. Yes, I create this trust. For whose benefit? From the word benefit. Who should benefit? What will they get? That will also be clearly spelled out. And these days, we are encouraging having an enforcer. An enforcer exists, or a protector exists to ensure, as an independent person, to ensure the trustees follow the dictates of the trust deed. This is to ensure that trustees are not the, everything in a trust. They have somebody who watches over them independently to make sure all they do is of the beneficiaries. Moving on, what are the trustees? As I said, it comes from the word trust. They must be trustworthy people. They manage and invest trust property. They distribute benefits to the beneficiaries as dictated by the trust deed, including according to their discretion, if they're given discretion by the trust deed. They must keep and maintain trust accounts and records. Are requirements of trust accounts, proper books of accounts, remembering this is not the trustees' assets. They will account to the court if called upon, to the beneficiaries want. They will account to the enforcer if one exists. So it's a fiduciary relationship where they manage assets not for themselves. And then they must protect the trust assets. Make sure that they don't go to waste. Make sure that they are well taken care of. And they must keep trust assets separate from their own assets. Let me touch briefly on the duties of an enforcer. What are the duties of an enforcer? An enforcer's work, as I said, is to oversee, have oversight over the work of the trustees to ensure they are compliant with the trust deed. They approve major trustee actions. For example, if trustees want to sell a major asset and the trust deed said for them to sell this major asset, the enforcer must give consent, then the enforcer must give consent. Then they act as neutral arbiters between trustees and beneficiaries. They have no interest, they're independent. So they're able to sit with the trustee and beneficiaries if there ever was a dispute, for example, and they can act as a neutral mediator, and they can prevent going to court over disputes that can otherwise be resolved. And of course, they report trustee misconduct if there's any. And we've known trustees who really just go in and try to enrich themselves. The enforcer ensures that that is not that does not happen, and something needs to be reported to the court, because this is under the law. Remember, you're doing duties which are imposed by the law in addition to being imposed by the trust deed. The enforcer is able to report those. Now, it is recommended, that discussion point, that enforcers must be independent people without an interest in the property, people without an interest in the beneficiaries, people who are not trustees. You cannot be a trustee and enforcer at the same time. And as a settlor who is creating a trust, you've got to decide, do I want this person to be my trustee because they can administer very well, or do they want them to be sitting above the trustees as the enforcer because they can oversee the work of the trustees faithfully? So that's important for us to remember that. And I've touched on how you choose people you can trust, choose people who are honest, choose people who you know are good stewards of assets. And because you don't have to have only one trustee, you can have a good mix of family and profession, knowing that generally the family trust are for family benefit. And the same thing with an enforcer, except an enforcer should be independent. All right? And I think that's what I'm going to say about trust. It's very, very quick and because of time. But to choose one last one, how do you choose the right estate planning tool is a quick one. How do you decide on it? We recommend very, very highly the advice of experienced lawyers. I think when Sima was introducing us, you probably realized we are terribly experienced. We are very, very experienced. And so we recommend ourselves to begin with. But if not us, get an experienced lawyer. You must get your trusted, your estate plan planned with you by an experienced legal practitioner who will help you navigate some of the things you said. They'll take into account, and you will take into account in creating an estate plan, what do you own? Are they for profit? Are the businesses profitable themselves? Are they cash? Are they investment? How do you want them to be when you're no longer the one running them? Who are your dependents and how are they? What are they doing? Are they minors? Are they adults? Do they have special needs? Do they need special care? Are they reckless? And so on and so on. And what are your intentions? Do you want other people outside the family to come into your company? Do you want to keep the family business running beyond your lifetime? Because if you do, then you probably want to put it in a trust arrangement. And when do you want your estate plan to begin? Do you want it to begin now so that you put it in a living trust? Or do you want it to only kick into effect once you are no longer here, in which case a will and a testamentary trust may be sufficient? And what risks are you trying to manage? Do you have some interesting entanglements that you want to deal with? Are you uncertain about who your relatives really are? Do you know how many children you have, for example? Things like that. Each of those are going to, when you take them into account, they're going to help you determine what estate plan you want to have. And of course, to do all this and to do it correctly, especially when it comes to trust, you will need some good tax advice. So not just an experienced lawyer, but an experienced tax advisor. Thank you very much. I think that will set us on the way to a good estate plan. Thank you.
Thank you. I think you all enjoyed the session, I believe, from the speakers, and I know there's a lot of information that has been given. You have a lot of questions. I've already seen some of them, so thank you for engaging with us. And maybe as you continue posting your questions, just tell us what is one thing that you've taken away from this session that you probably didn't know, or something that has struck you and it is interesting that you have learned it now. I'd love to hear more about that. We will take some of your questions, and I'm going to invite Sima back to do that. Karibu Sima, over to you.
Thank you. Thanks, Irene. Wow, what a fantastic set of, or pieces of information that I've also learnt myself. First of all, the one that struck with me was 1 billion shillings spent within the judicial system to sort out cases that have just not been handled properly. That is an alarming number. And guys, we don't want to be part of that statistic. I think it's really important to ensure that we just take our future into our own hands. Really, the other thing that stuck with me was you said 30% of your wealth actually translates to the next generation. I was just reading something in Europe, and what they said is that in Europe this was 40%, And through a lot of education and ensuring that people are actually looking after their futures, they've managed to shift it to 60%. So this is something that actually is within our control. We need to shift that 30% number, and you said 5% for land. It's for third generations, which is, you know, there's no point in working. You might as well say, let's not work today, because what's the point? So we really must take it into our own hands. And I think the team has done a fantastic job of really educating us on the same. Remember, this video will also be available on YouTube, so you're able to just go back and listen to the nuggets that our panelists have shared with you today. As we come to the questions, Iveen, I don't know if there have been any questions that have been placed on the chat so far.
Yes, there are a few questions, and maybe just to note that we will answer all questions. Even if you're not able to answer it now, we will send, it will be circulated, the answers to every question that has been asked in the chat box. But maybe I can start with one question to Gladys. So what happens if I have debts and I've already put things in my will? What happens to those debts?
As much as we say that you will distribute your assets, these are the assets that are going to be distributed, the first thing that needs to be taken care of is debts. So I may say that I'm leaving 5 million shillings to my daughter, but the fact that I have a debt of 1 million shillings means that the distribution to my daughter will be much less, because the debts have to be paid off first. It might even mean that there's nothing left in your estate because of your debts. So it's not guaranteed.
And maybe just another question to you. What happens if I was married, I divorced, in the settlement, my wife had custody of the children, and she passes on? Are my children, and she had remarried, where do those children inherit from? From their stepfather or from me?
Because you're their father and you're their natural father, it depends on the relationship that you had in the first place. Were you, even though she had custody, did you have visitation rights? Were you considering them your children? And if you were, those children will inherit from you. If, for example, she remarried and the other husband took responsibility for the children, and the word here is permanent responsibility for your children, then they will inherit under the new husband. But if not, then they will inherit under you. And there's been some court decisions that say you can't double inherit, you know, for the children. So, you know, I think each circumstance is different. So if you were the one who was supporting your child, it is your child will inherit from you. If the other person assumed permanent responsibility for the child, then the child will inherit from that other person, that other dad.
We've been referring in the slides a lot to wives. And I know, Peter, you felt left out, so you also made a point to state that you're representing the boy child. And I think a lot of us assume that, you know, in this day and age, it's the wives that need to be looked after. A lot of women are working, and in a lot of cases, actually, the breadwinners. How equitable is our system to allocate wills and inheritance?
Well, when it comes to provisions, leaving reasonable provision for your dependents, one of your dependents is your husband. So the law changed to include, before it used to be wife, but now the law changed to say spouse. So you must leave reasonable provision for your husband as well.
Fantastic.
Yeah.
So we're now living in a modern world, which is
Almost,
exciting.
almost modern, not
almost
quite.
there. And maybe if I could also ask Peter a question as well around trusts. A lot of our clients also have wealth that they've accumulated offshore. Could you just highlight what it is that you can offer from an offshore perspective? How can you, because the jurisdiction is different, do you have the technical skills to be able to handle those trusts as well?
Yes, I can confirm that, as Sima said at the beginning, we are part of TAG Law, which is a network of independent quality law firms in the world, in 180 jurisdictions in the world. If you wanted to discuss trusts, both for assets in Kenya and offshore, we will work with a law firm from one of those jurisdictions, which is in our network, and ensure that we deliver to you a complete service. So that they can bear in mind the laws of the particular jurisdiction. We do not hold ourselves out as practicing law other than the law of Kenya, but we do work in teams and with the firms that we're in partnership with to ensure that you can get a composite service. Yeah.
Back to you, Ivy.
Thank you. So one last question, maybe to Peter. So is my 6-year-old son a child?
Yes, for purposes of inheritance, a child is a child regardless, for so long as they are conceived. That's why even a child who is not yet born, by the time the person passes away, is considered their child. For so long as they have not then died, they remain a child for that person and must be provided for however old. The key word here is making reasonable provision in your will. It doesn't mean it must be the same. And that's a distinction. When you do a will, then you can distinguish depending on the particular circumstances. There are many parents who have children who are way richer than them, for example, and who are helping them support the other children. So when it comes to doing a will, it's likely that such a person will provide less to the richer person who is more able, who is being helping support the other children, provided that in the eyes of the court and in their own eyes, they can explain that this is a reasonable provision. Say I took this child through a lot of education. We sold many of our properties in order for him to go to school because he could. And so giving him 1 million shillings while I'm giving 20 to the others is reasonable in the circumstances. And there'll be times when we advise clients to explain the reasonableness of their gifts in the will, so that anybody looking at it from outside can understand why would this person be given so little. Others, for example, is you've given a gift inter vivos, for example, given somebody a property, and you give them less in the will, but you get an opportunity to explain, given what I'd already given them recently, transferred to them, this is reasonable in the circumstances. But quick answer, a child is a child is a child. However old, whether married to the spouse or not, whether they got a stepfather, half-father, whatever it is that they got, they're your child, your biological child.
Good. So I hope you understand that even your 40-year-old child must be included in your will, and you cannot leave them out because of that basis. And maybe and I know, Peter, you didn't want to discuss too much about the tax, and there are tax advisors, but can you mention a few tax benefits that one may get in a trust?
Yes, one of the things that you get is, today if you transfer property, you pay capital gains tax. When you transfer that to a registered family company, you don't pay capital gains tax. And the trustees do not pay stamp duty to receive that property. That is one thing. One of the other reasons that you use trust is to manage your own tax benefit. Now, if you do a transfer to an irrevocable trust, then any income for that property which is in an irrevocable trust is not any revenue, any income is not part of your income for tax purposes, and that will be taxed on the trust itself, depending on the rules that operate over taxes in that particular trust. So there are a few benefits, and you need to know: do I need to register? Do I need to incorporate? What do I need to do in order to get this particular tax benefit?
Thank you so much. So there are many questions, but some of the questions that we've seen is one of those questions where we say estate planning is very unique to different people. So one of you has asked, do I put my property in a family company or in a family trust? That is advice we can only give after we meet with you and we discuss and we see what your situation looks like and what you're trying to achieve, and then we are able to advise, because again, estate plans are very unique. So you do need to meet with us for us to be able to give further advice on such instances. But thank you to the team for the presentation. I think we can close the Q&A session at this stage, and we will make sure to answer any other questions that were left out, and the answers will be circulated to you.
Thank you. Thanks, Iveen, and thank you to the wonderful set of panelists who have credentials that go from here to here. I think it's been a really interesting conversation and never exciting to talk about the eventuality of death. But that's the one thing that will never change, and it's really important that you ensure that you, what do they say, you can't predict the future, but you must prepare for it, and you must prepare for it. And I think that's really what we wanted to bring you today. I hope you've been empowered with the conversations that you've heard today. We are going to be available to you, and therefore we'll share information about how you can access us. If you bank with Absa, please do get in touch with your bankers or your relationship managers for more information on how to connect with the team so that you can have that one-on-one conversation with them. That is critical to have right now. Like I said, there's never any time but right now to do these kind of things. And the final thing is, remember, whatever it is that you've got, it is important enough to protect. You don't have to have reached a certain milestone in life in order for you to say now is the time for a will. The time for a will is right now. Thank you so much for watching. We're going to have more and more of these webinars as we get into the future in our series, and we look forward to seeing you on more of them. Thank you so much.